I went to Igbo court with Osinbajo one day. I came out, I went into my jeep, I shed tears. 4 big rats out of Chief Justice's office. And you ask yourself, why will these people, why should they be dedicated to the cause of Lagos? Why should they be dedicated to the cause of justice in this country? He said, Yemi Osinbajo says, that where you go, he said, you see it yourself firsthand. You know those couches, sofa with spring foam. You see, it's George and Chief Justice Office springs coming out of the rubber foam. You know, unfortunately, I don't know whether we have the picture somewhere. And they'll look up at the ceiling, holes, and that's where one of the rats dropped. So, I can't tell you this story today. We take the entire month or year to tell this story. Reform program and how to break the overbearing authority of the federal government on the state revenue, state opportunities. And we have that challenge of being the opposition party. We broke the yoke. We are determined. I went to court with federal government several times over on federalism, physical federalism. And we won all the cases, thanks to the Nigerian judiciary. We did our judicial reform. We gave our judges hope. We gave them, the future they can think about. Remunerated well. You see, the question of corruption that we are still tackling in this country must be guided, evaluated, and tackled like a sandwich too. If you don't want your people to be corrupt, pay them well. If you don't pay their salaries well, don't give them living allowances that can even give comfort. Particularly judiciary that has, have no voice, no media voice.
Coming to the point of the justice sector team, I think one of the critical things that Asiwaju again had identified was the fact that what you needed is not just a going to court attorney general. You needed a justice sector reform, and it was the justice sector reform plan that our policy committee had developed that I simply implemented to the letter. We had the good fortune that the chief judge at the time, Justice Shegun, was very amenable. As a matter of fact, I met him within a week of my being appointed, and laid out the plans. He was extremely amenable. Said, look, you're in the driver's seat here, go on and do what you need to do to bring this about, and supported all the way. In the same way, as time went on, we also, there was also Justice Shotiminu, who was also extremely supportive, Justice Adeyinka, Justice Alabi, all of them were extremely supportive. And that was very important, because without the working together of the judiciary and the executive, and of course the legislature, but in this particular case for justice sector reform, we really needed the judiciary and the executive working together. And we had an excellent working relationship. It was so important in what we were going to do, because what we were going to do was going to be quite revolutionary. There are so many things that had not been done before that we thought we should do as part of our justice sector plan. But another aspect of that, and maybe we might have time to discuss that, are the various litigations that we had to undertake in order to press home the point of federalism, in order to press home the point of restructuring Nigeria, which has become quite popular now. But I think that one of the things that, again, Asiwaju championed a great deal was the whole question of federalism by litigation. I think that he pushed that, that look, we can go to court and get our rights. And we did. We were in court in the Supreme Court, in almost 12 different cases, which defined, even till this very moment, the structure of our federation. For example, when we went to court when Bola Ahmed, who was then Attorney General of blessed memory, went to court on the fiscal, on the literal states issue, so-called resource control. We counterclaimed, and we made there were so many different issues that we raised in our own counterclaim. So our counterclaim became more or less the subject of the suit itself, because we're asking for all sorts of issues around fiscal federalism. We're asking, for example, that because we had a port should be declared a natural resource, and so we should be entitled to derivation on account of the fact that we had a port. And so many different issues, that the first line charges, that were in place before should be removed, that all payments should be paid to the Federation account and shared, which wasn't something that was being done before. So many different issues came up in that suit. And then subsequently, we were in court over the issue of planning permission. Who had the right to give planning approval in the states, even where the land was federal land, even where the land that was designated for military or whatever purpose? Who had the right to grant planning permission? As a matter of fact, before then, there was the Urban and Regional Planning Act, which was a national legislation. And that legislation purported to give rights to the federal government to grant planning permission and approval with respect to federal land in the states. So we contested that, because they would say, for instance, that under the bridges, the loops under the bridges, that those were federal land. And so they controlled it. So the federal government controlled it. They would say that the setbacks of the highways were federal land, so they controlled it. And then they would also insist that anywhere where there was federal land, they had the right to grant approvals, which was, of course, contrary to the type of federalism that we thought we were after. So we went to court and contested it, and we won. It was a slim victory at the Supreme Court, to tell you how contentious it was. 4-3, because it was a constitutional court. And we won, and so the court declared that it is within the legislative competence and within the executive competence of the states to give planning permission, to make laws on planning, and control planning permissions and controls, and all of those things were legitimately the right of the states. So the states, of course, have been enjoying that seat. We also went to court over the local government issues.
Popular.
Yes, the popular local government issues, where we had insisted that states had the right to create local governments. And we created 37 local governments just to demonstrate the fact that we had the right to do so. President Obasanjo at the time stopped funding, of funding to the local governments on account of the fact that we had created 37 local governments. A few other states had joined us who had also created local governments. But when we went to the Supreme Court, one by one, the states all negotiated the federal government, but we remained steadfast. And the simple reason was that Ashiwaju said, no, we're going to fight this and get a conclusion. One of the very important points that arose from that case was first, that the president of Nigeria has no authority to stop the funding of any state. That was a very important issue. Because you see, the president then had asserted, and it appeared even reasonable then, at least from their point of view, that if a state misbehaves, if a state, this is their argument, that if a state, for example, wasn't even spending its money right, or a state had gone to set up local government, establish local government as we did, in their view, contrary to the constitution, then then the federal government could stop their funding. So we contested that and said, as far as Section 165 of the Constitution was concerned, what the president is supposed to do is to simply, the federal government is supposed to share the money from federation account. They had no right to withhold it in any way. And the court agreed with us that the president has no power, to withhold the funds of any state or local government. It was a very important point. And the second point was that states indeed had the right to create local governments. And they found that the local governments we had created were legal, but that they were inchoate, incomplete, in the sense that we still required the National Assembly to include the new states, the new local governments were created in the schedule, which listed the local governments and all of that. So we maintained our local governments and passed the local legislation, which made them development LCDAs and all that, local government development.
So it was such a pioneering work.
Absolutely. And this is really the point. You look at a lot of what has happened in terms of the progress that we've made in fiscal federalism and all of that. It was on account of several of those cases. It was on account of those cases because the cases we went to court clearly with a view to establishing, to the extent possible, the autonomy of states within the 1999 Constitution. And it was for Bola Tinubu, it was really a passion that he had. This was a great passion that he had, that we had to establish the autonomy of states. We had to show that states could be independent. As a matter of fact, one of the big advantages of our creation of local governments and the stoppage of our funds was also the financial engineering that went into establishing establishing Lagos as practically financially independent. Because it was then that we worked very actively on our IGR, worked actively on creating the LIRS, the Lagos Inland Revenue Service, and several other strategic developments, such as the land use charge, which at the time, of course, was unknown, anywhere. We did was the land use charge and all of that, in order to build a financial base for Lagos State. And I think that one of the enduring achievements of that administration was the fact that that financial base was laid solidly, and subsequent administrations have built very, very commendably on that foundation. So really, I think that what happened in Lagos State, of course, we did in the judicial and the justice sector space. The Office of the Public Defender is usually something that's
I think
well
it was
known. Yes.
something that came up.
Yeah. The Office of the Public Defender. Basically, what it was that we had thought that there was a National Legal Aid Council, which is a federal legal aid council, which was to provide legal aid for persons who are unable to afford legal aid. But National Legal Aid Council had a threshold, for eligibility for legal aid, and the threshold, in our view, was, I think if you were earning less than 1,000 naira or 1,200 or something like that, which really wasn't useful. And again, there were not enough lawyers in the National Legal Aid team. So we decided that we must set up a legal aid facility for Lagos State persons who are resident in Lagos State. A facility that would not have a threshold. So you would come to the Office of the Public Defender if you had any rights matter or any issue whatsoever that you thought you needed defense for and you couldn't afford to defend yourself, you couldn't afford legal fees and all that. And we set up the Office of the Public Defender. We had several branches of it all over Lagos, and people could come in and they could come in there without, just explain what their problem was, and they'll be defended. It was very, very, in fact, it turned out to be much more than we thought it would be, because, we had the very active leadership of now Justice Akinlade. Justice Akinlade, by the way, she was so passionate about BC Akinlade. She was so passionate about the position, about that organization, Office of the Public Defender. She was the first director of the Office of the Public Defender. And she went about her task in such a remarkably professional way. So, because nobody had ever done that sort of thing before. In fact, she was at various trouble spots, wherever there was any development. For instance, when we had a fire at the Korodu, there was this Chinese factory that had a fire and several people died. Yeah. The first responders was from the Office of the Public Defender. Yes. And she took up the case and all that. They also at the Ikeja cantonment. She took up the case, and the Office of the Public Defender took up the case. And what happened then was that so many people, all of those who suffered during the bomb blast, people who lost family, lost property, were all compensated, because the Office of the Public Defender went after the government to ensure that they were compensated. So the Office of the Public Defender really was revolutionary in the sense that people began to believe more in government being their representative. We came from the military rule. And the military rule, the Ministry of Justice is always a place for law and order, right? Just law and order, just ensuring that people are, behaving themselves. But when we came in as a civilian administration, one of the key policies, which we have developed as part of our justice policy, is that we must become a ministry of law and justice. We must become the defenders of the people. The rights of the people must play a major role in the work of the Ministry of Justice. So we set up what was called the Directorate of Citizens' Rights. For the first time, a whole department was created. In most traditional ministries of justice, you have public prosecution, civil litigations, drafting, etc. But we set up for the first time the Directorate of Citizens' Rights, which has clearly established that under civilian rule, the role of the Ministry of Justice is different from under military rule, because the people's rights must, take center stage. So the Directorate of Citizens' Rights actually managed the affairs of the Office of the Public Defender, something we call the Citizens Mediation Center as well, which was like a small claims court where people could come from anywhere and litigate their cases before a trained mediator. And we had the Citizens Mediation Center also in different parts of Lagos. We had on the island. They're still there. We had them on the island. We had in the ministry itself. We had in Yaba. They're all over the place. So you could literally walk in, make a report, and then we'll invite whoever it was that you wanted to contend with, and the matter will be resolved by a trained mediator. We trained so many mediators and so many people we worked very hard on that. But you see, the whole point of it was that the Ministry of Justice was meant to be and served the purpose of being, the vehicle for the purveying of the rights of the people. So it was a place where the rights of the people was taken seriously. People could come there and make their reports. We also had a consumer protection unit in the ministry, which enabled people to just come and make reports about consumer protection issues and all of that. So it was quite, all that, was quite important as a way of, demonstrating that under civilian rule, democracy also means that the rights of the people must be taken seriously. But I think also, quite importantly, one of the things we did was also the reform of the civil procedural rules. Delay has always been a major problem of our administration of justice system, the time it takes to process cases through the courts. So we did all sorts of surveys on, delays and what we could do to reduce the time. So we undertook a whole reform of our civil procedural rules. The whole concept of front-loading, on some very important dramatic changes that took place in those days, resisted at first, but I think over time, people realized that this was the way to go. And I think the civil procedural reform was an important part of our justice sector reform. And a lot happened, when we were able to do so, we were able to reform the procedural rules. So it helped a great deal. Yes.
Will he ever get there? Oh yes, he will. Will he ever make it? Will he ever hear the sound of the cockcrow at dawn? Will he ever hear the sound of the cockcrow at dawn? Will he ever get there? Oh yes, he will. Will he ever make it? Will he ever hear the sound of the cockcrow at dawn? Will he ever hear the sound of the cockcrow